Let's get weird into it. Number 8. Pillowed footprints. Imagine waking up to a muddy trail that leads not out of the house, but straight to the bed. Footprints. A smear of blood on the duvet. Your partner on the floor claiming they woke up with a cut. Your immediate instinct is detective mode. Who? When? Why? The stranger answer that haunts these cases is, it might have been you, while you were asleep. Forensics here is deliciously ambiguous. You have the hard stuff, prints, fibers, blood spatter geometry, that seems to pin movement and contact to a person. Then you have the soft medical context. Prior parasomnia, sleep deprivation, alcohol or sedative use, and sometimes sleep study notes showing a propensity to complex behaviors during deep sleep. The physics can say where someone moved. The physiology can say whether their brain was likely online for intentions. What trips juries is the mismatch between a tidy physical picture and a messy human story. Fingerprints on a nightstand look damning. A documented history of sleepwalking makes them explainable. Experts will argue over motor coordination. Were the movements clumsy and reflexive or directed and purposeful? A knife held cleanly and used precisely invites suspicion. A clumsy, unpredictable pattern of cuts might be consistent with involuntary action. The law, however, doesn't like uncertainty, and sleepwalking sits squarely in that gray zone. The nightmare scenario for a defendant is having the body stage the crime while the mind sleeps through the whole thing. The nightmare for victims and juries is being asked to weigh microscopes against the idea that a person can commit complex acts without intent. Both are true in different ways, which is why these cases feel less like puzzles with one right answer, and more like moral dramas where science does what it can and humanity has to make the call. Number 7. The highway driver. Picture a car veering over a guardrail at 3 a.m. The driver emerges claiming no memory. Welcome to sleep driving, a modern, terrifying twist on somnambulism. Cars leave digital breadcrumbs, GPS tracks, telematics, dashcam footage, and brake/steering logs. Those records can show deliberate-seeming maneuvers across miles, which prosecutors love. It looks like intent on paper. But humans have procedural memory. How to drive a route you've rehearsed 1,000 times can run while episodic memory is absent. Accident reconstruction experts analyze steering inputs and jerk patterns to judge whether actions were reactive, unconscious, or calculated, conscious. Add toxicology and sleep medication histories into the mix, and the question becomes clinical. Was the brain in a parasomniac state, or was the driver alert and culpable? The legal fight turns on plausibility. Modern vehicles make the body's half-asleep scripts legible, but legibility isn't the same as meaning. A GPS trail that shows a purposeful route can be interpreted as either intentional behavior or an automatic program executed by a sleeping brain. Judges and juries must choose which story fits the available science, and sometimes they accept neither, which is when verdicts become messy compromises. Number 6. The kitchen butcher. You walk into the kitchen at night, and a domestic object becomes a weapon. These cases are headline grabbers. Knives, blunt instruments, and blood patterns that scream violence. Forensic pathology maps wound angles and force. Blood spatter analysis tries to reconstruct the choreography. If the pattern is chaotic, smeared transfer stains, defensive limb injuries consistent with stumbling, it can support an involuntary narrative. Sleepwalking can produce surprisingly coordinated behavior. People have been known to cook, drive, or leave the house while technically unconscious. The difference in court is whether the behavior looks purposeful. Defense teams bring in polysomnography records and medical histories to show a predisposition to parasomnias. Prosecutors point to the physical evidence and any possible motive to argue volition. What's unnerving is how ordinary things become incriminating props. A kitchen knife's trace evidence is cold and concrete, but the mind behind the hand that wielded it may have been offline. For jurors, this collision of the material and the mental force is a hard question. Do we judge the body or the conscious agent? Often the answer depends less on definitive proof and more on which narrative the experts make feel credible. Number 5. The bedroom stranger. You wake up somewhere that feels wrong. Another person's jacket on you, a lamp smashed, your partner missing. Evidence may suggest an intruder, displaced bedding, unknown fibers, maybe an altercation. But sometimes the intruder never set foot in the house. Instead, the accused's own nocturnal wandering created a scene that looks like home invasion. Investigators lean on building forensics, keycard logs, CCTV in hallways, elevator timestamps, to check whether an external person actually entered. If none are found, attention turns inward. Sleep history, witness reports of prior night wandering, and whether medications or alcohol could have triggered parasomnia. The courtroom becomes a detective story where the neighborhood's small, usually invisible details, late-night visitor logs, deliveries, neighbor statements, matter as much as DNA. These cases are socially awkward because they confront intimacy. Your own body can act like a stranger. Families are torn between sympathy and fear. Jurors have to decide whether to trust a medical explanation or the plain reading of physical traces. Either way, the human cost is real. Number 4. Phone records don't sleep. Your phone remembers everything. Pings, GPS breadcrumbs, texts sent at 2:14 a.m. That digital trail becomes both weapon and evidentiary lifeline in sleepwalking cases. Phones and apps record precise timestamps that can build a minute-by-minute narrative, often making the behavior look deliberate and rehearsed. But habit and muscle memory are powerful. The thumb that knows how to unlock your phone, scroll to a message thread, and tap send may do it while your conscious self is AWOL. Forensic analysts compare phone logs to surveillance footage, receipts, and witness accounts to test whether the behavior is consistent with voluntary action. The big legal hurdle is convincing a jury that a clean, precise digital trail can be produced by an unconscious actor. In some cases, corroborating sleep study records and medical testimony help. In others, the tech trail is a convincing story of intent, regardless of any sleep disorder history. The modern irony: your most reliable alibi may be the one device that also makes you look the most guilty. Number 3. The hotel room mystery. Transient places like hotels are catnip for nocturnal misadventures. Privacy rules mean less in-room footage. Layouts are repetitive, and jet lag or unfamiliar beds can trigger parasomnias. Forensics will chase keycard swipes, minibar charges, front desk logs, and corridor cameras. Tiny threads that make or break timelines. Hotels also introduce third-party ambiguity. Housekeeping claims, mistaken room entries, and confused witnesses complicate narratives. If a guest has a documented history of sleepwalking intensified by travel or medication, experts may argue the episode was involuntary. But if keycard data and hallway footage show purposeful movement, the prosecution gets a tidy story. The drama here is documentary. Transient stays produce transient evidence, and gaps are exploitative. Waking up cuffed in a police room after a hotel incident leaves you arguing not just with peers about intent, but with a patchwork of records that may or may not contain the truth. Number 2. The confessional sleep. Sleep-talking recordings are emotionally devastating. A half-asleep voice on a partner's phone confessing to something, a threat, a plan, an admission, is visceral, personal, and persuasive. Forensic linguists can analyze voice prints and prosody, but they can't definitively prove the speaker was asleep when the words were uttered. Brains can produce fluent, contextual language during parasomnias. That means a recorded confession might be an automatic utterance rather than a deliberate admission. Courts weigh context heavily, timing relative to the alleged crime, corroborating physical evidence, and the speaker's sleep history. A juicy midnight monologue that mentions private details the speaker shouldn't know is dangerous. A vague, angry muttering is less decisive. The social sting is also real. Loved ones hear a voice they trust lying in ways their hearts interpret as betrayal. Legally, the question becomes translation. Is that recording an objective piece of truth, or a symptom of a brain that temporarily hijacked the tongue? Number 1. The Nightstand Trial. This is the intimate cinematic case. A body, a weapon, your prints on the nightstand, a bloody knuckle, a missing memory. Forensics is exhaustive. Fingerprints, transfer DNA, blood pattern analysis. And the prosecution crafts a narrative of access and intent. The defense counters with sleep specialists who describe how procedural memory and motor programs can operate without conscious oversight. The crucial pivot is voluntariness. Were there triggers? New medication, sleep deprivation, recent surgery, alcohol, that could plausibly induce an automatism? Could a habitual nocturnal ambulator have performed goal-directed actions while the conscious self slept? Expert testimony can be persuasive, but it rarely yields certainty. Judges and juries must absorb physiology, reconstruction, and human testimony in a compressed time frame, and then choose which story to believe. The cruel truth is this: the body can perform competent, sometimes vicious acts while the mind is absent. The most real evidence can belong to an actor who wasn't directing the play. That forces legal systems, and the people who live inside them, to make agonizing calls about blame, intent, and mercy. That's all for today. I'll be making similar videos in the future. Subscribe to see them.